Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about burglary and the many different definitions of burglary and the many different levels of burglary, starting at misdemeanor all the way to violent felony strike burglary. So let's talk. Penal Code Section 459 is sort of like shoplifting. It's a derivative of the 459, 460 series of the Penal Code. That's a situation you go into a store. They believe you had the intent to, commit an offense when you walked in and you took something. Okay, your run-of-the-mill, what used to be charged as a petty theft is now a traditional shoplifting. Penal Code Section 459.5. In nearly every instance imaginable, that is going to be a misdemeanor offense unless the amount of property taken is significantly over $950. Penal Code Section 459 is commercial burglary. Entered a commercial establishment, let's say an office, let's say a mill, a business, whatever the case may be, not during business hours with the intent to commit a felony or theft inside. And then Penal Code Section 459 has certain attachments to it, which you don't like to see if you're accused of burglary, one of which is Penal Code Section 460, which is residential burglary. And that makes what is a felony or could be a misdemeanor burglary, it makes it a non-reducible felony burglary, and it makes it a serious felony, which makes it a strike felony in the state of California. And that's if you enter a home with the intent to commit a felony or a theft therein. Well, how are they going to prove that? Well, a lot of times if you enter the home and it's not yours and you walk out with stuff, intending to steal it, it's pretty obvious, right? It sort of speaks for itself. But, it doesn't necessarily mean even entering a house where you're thinking someone with a mask in the middle of the night. It could even be an invited guest, and when that guest comes into your home, they had the intent formulated to commit a felony or a theft inside. It could even be walking into a room within the house, and if the intent was formulated inside the house before they broke the plane of that room. So very important differences, very important issues sometimes when you're dealing with the dwelling. Is it a detached garage? Does it have access to the house? All of those things. Is it an inhabited dwelling? Did the people move out? All those types of things are really, really important to assess in determining whether or not the case has been charged appropriately by the prosecutor. And finally, with regard to burglary, there's the dreaded hot prowl residential burglary. What that means is that someone was actually in the house at the time the burglary was committed. Doesn't mean you had to see the person. Doesn't mean they had to see you. Doesn't mean you had to alarm them. Doesn't mean that they were alarmed by you. All it means is that they were in the house. They could be sleeping through the entire encounter. And you will be charged in all likelihood with burglary and the allegations that it was a residence, which bumps it up to a strike felony, a serious felony. And then the allegation that it was a hot prowl, which bumps it up to a violent, the most serious type of felony, where you're serving a state prison commitment anywhere, early part of the 2010s. It was, you're doing around 85%, and before then, traditionally, you would have to serve 85% of your sentence. Then it got bumped down with Prop 57 to about 80%. Now it's arguably in 2021 down to about 2/3, so you're serving about 67%, maybe. Ultimately up to California Department of Corrections and Rehabilitation. But residential burglary and hot prowl residential burglary is definitely something to be taken seriously. One of the more serious offenses you could be charged with, not taken lightly anywhere, particularly not taken lightly by the San Diego District Attorney's Office. So, this video, we went through the different types of burglary, pretty much from your run-of-the-mill shoplift through commercial burglary, through residential burglary, and through hot prowl residential burglary. Hope you found this video helpful. If you find yourself or a loved one charged with burglary in any way, shape, or form, it is imperative and essential that you reach out to and ultimately hire a quality, locally experienced criminal defense firm that in the jurisdiction. So if your case is in San Diego, you want to hire a San Diego criminal defense firm with a reputation to back it up, a reputation you feel comfortable is going to handle your case the right way, no matter where you fall, no matter who the attorney or record is within that firm. So if you have any questions, again, about burglary in any way, shape, or form, or any criminal case in San Diego County, you can always give my firm a call at 619-295-3555. Again, my name is David Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro in San Diego, California.